10 seconds, 5 seconds, start. Section 324B also reiterates the same principle by providing that when a person who is otherwise competent to compound an offence is dead, his legal representatives, as defined under the Code of Civil Procedure, may, with the consent of the court, compound such offence. Therefore, representation of the person compounding has been statutorily provided in all situations. Relying on the aforesaid clause in section 147 of the NI Act, learned counsel for the appellant argued that a three-judge bench decision of this court in the Modar case held that in view of the clause in section 147 of NI Act, which is a special statute, the requirement of consent of the person compounding in section 320 of the code is not required in the case of compounding of an offence under NI Act. This court is unable to accept the aforesaid contention for various reasons. Thereafter, a similar request was made to the Speaker by Shri Dharam Singh, another member of the Vidhan Sabha elected as a candidate of the HJC, to recognize the meagre of the HJC with the INC and to also recognize him along with the other four legislatures as members of the INC in the Haryana Vidhan Sabha. Subsequently, another application was filed by Shri Dharam Singh before the Speaker on 10th November 2009, requesting him to be recognized as a part of the INC in the Haryana Vidhan Sabha. The Speaker by a separate order allowed the said application upon holding that the same was in consonance with paragraph 4 of the 10th schedule to the Constitution. Challenging the aforesaid orders, the respondent number 1, Shri Kuldeep Bishnoi, filed 5 separate petitions before the Speaker under Article 191, read with the 10th schedule to the Constitution of India and the Haryana Legislative Assembly Rules 1986 on the ground that they had voluntarily given up the membership of their original political party and had joined the INC in violation of the provisions of paragraph 4 of the 10th schedule. On receipt of the said petitions, the Speaker on 22nd December 2009 forwarded copies thereof the concerned MLAs, asking them to submit their comments within a period of 3 weeks. On 7th April 2010, applications were received by the Speaker from the concerned MLAs praying for time to file their written statement. The matter was accordingly adjourned and further time was granted to the concerned MLAs to file their explanation. The respondent number 1, however, filed a writ petition in the Punjab and Haryana High Court seeking quashing of the orders passed by the Speaker on 9th and 10th November 2009 and also for a declaration that the 5 MLAs in question were disqualified from the membership of the Haryana Vidhan Sabha and in the alternative for a direction on the Speaker to dispose of the disqualification petitions within a period of 3 months.